in the Supreme Court Chief Justice's own words. And that's why I guess it survived for so many years. But I just find that it's just not happening, and the comprehension by the jury is not happening. It's just not happening. We need to make it very clear in layman's terms, and it must be done in every case so they're aware of it. And it's just not happening. So I really have a hard time trying to find out what the harm is or where the detriment is in having that justice make sure these instructions are quite clear, to the jury. I think we should be doing everything we can to make sure they understand what the law is and how the law is applied.
Representative Saporito, do you have other examples of where in legislation this branch provides specific language that a judge must follow in jury instruction or in any other part?
Oh, we could. We could get State versus Weitzman. We could get all the other cases that are mentioned in here, State versus Doherty.
I'm sorry.
Those cases, you mean?
I probably didn't state my question clearly enough. I'm sorry. I wondered if you were aware in the RSAs of any other examples of where the legislative branch provides a specific script for a presiding judge.
Sure, Miranda rights. That's not to a judge, but let's see, one would be maybe Miranda rights. I'm sure, I'm not a lawyer, so I'd probably, if I was a lawyer, I'd probably be able to cite a few, some of the circumstances, but,
you say that with such pride,
well, most people think that, a lot of us are lawyers. No, I know that if we make the laws, they're interpreting them. I do know that the procedures in the laws, the rules they follow are we do here in the legislature. They're not autonomous to the other branch of government. And all we're doing is this is a constitutional issue, I would think. To say that we have no impact on how the court should be run at all, or instructions at all for the courts, I think is something that we accept that we do. It's what we work together. And in this case, we're not really dictating them with the law, but what we're trying to do is make things uniform. We control their budgets uniformly. We control. We have lots of controls over what we raise in revenue.
I think Representative Sylvia has a question.
Thank you, Madam Chair. Representative, are you basing this proposed statute on Article 4, right of conscience?
I hadn't thought of that, so no, I could be, but I know it's not. My concern was the practicality of the law. If we believe in jury nullification, it is the law of the land, it's accepted practice. If that's the case, we're not getting the meaning of those instructions to the jury. They're not getting that instruction. And I would, again, that's why I should go to a jury and ask them if they understand, it's been clear. And then read this to them, and then tell them if they understand what the concept means. It's very concise. I'm all for making sure people are, particularly in the courts, are understanding of their role and what their position is and what their responsibilities are. And anything we can do to clarify that and make that uniform throughout the state is justice, is what we should be doing. It should apply evenly to all.
Thank you. Thank you very much. Representative Walker?
Yes, and thank you, Madam Chair, and thanks for taking my question. I share the concern of Representative Rowe about the exact wording requirement of this. How would you feel if an amendment said, the judge shall explain the concept of jury nullification to the jury, period? Do you insist on exact wording here?
The reason why this is the case is because some judges can explain it clearly, some can't. It's just the nature of people. Some people are. I'm trying to bring uniformity so that justice is provided in every court in our state. I was saying that it's not. I'm trying to. My purpose is to make it uniform, is so that they are getting these instructions, so there's no question that they had received clear instructions. And I believe under your suggestion that it's possible that they will not, because how it's interpreted by one judge versus another. You know, this is the Supreme Court Chief Justice's reaffirmed position, and it's exactly, I think, is what we, as legislators, when we voted on jury nullification, what we thought we were instructing. I mean, this is the wording for it. If you can find clearer words that explain it better, I'm happy for that as well. But I keep repeating, I think the court got it right. But the purpose is so that everyone is receiving equal justice and receiving equal instructions, and it's just not happening right now.
Thank you, Representative Rowe.
Thank you. Except for section Roman numeral 2, last term, we worked with the court to come up with a reasonable compromise. And the difference, basic difference here is last term we said your attorney can give this instruction. And you're saying the judge can give this instruction, should give this instruction.
Or both.
What is wrong with, if your defense attorney does not give the instruction, you may not be competent, but do you have any evidence that the court has not allowed defense counsel to give this instruction to the jury?
I want to pay $1,100 for a transcript of my Superior Court, my own case, and I'd be happy to give that to you. And you can see it from that. But it's cost me a lot of money to do that. But other than personal observance, no. And I do know that when my defense attorney, if I tried to go up and explain that to them, he was shut off, and if he continued, he would have been found in contempt of court.
Thank you very much. Representative Woodbury.
Thank you, Madam Chair. Thank you for your testimony. You read to us from a Supreme Court case, and the language apparently from that case you've incorporated into this bill. Can you just give us a citation, or better yet, give Mr. Cianci the citation so that we can have copies to read?
Sure. United States versus Moylan, M-O-Y-L-A-N, 417F.2D 1002, comma, 1006, 4th Circuit, 1969. Sir.
So we're talking then about a federal court.
U.S. versus Moylan. Yes, and this is the New Hampshire.
And we're talking about the Court of Appeals.
Right, and also I can give you one, a state, here's another one. It's in a number of these. Look at State versus Cody, 129 NH 358, 1987. I mean, it's referenced numerous times over and over. This is what's been going on for decades. This is the instruction. All I did was take what's already been there for decades.
Just a clarification, the quote you gave here for the instruction is from what case?
This is from, well, from State versus Cody, because I know it's there for certain. State versus Cody, 129 NH 358.
Thank you very much for taking the time to bring this to our attention. Representative Copper?
Yeah, thank you, Madam Chair, and thank you, Representative Separato, for taking the question. You said, if I understood you correctly, that in your case, when your attorney tried to explain jury nullification, he was shut down. Was that after we had passed? I just want to make sure the date's correct.
This is let's see, this is October of the past October.
Okay, so that jury nullification went into effect last January, and it was after that a judge in New Hampshire shut down your attorney from trying to explain that to the jury. Is that correct?
He was warned a few times that he would be found in contempt if he came close to being in jail than ever been in his 30-year career. Put it that way.
Okay.
And for a few things.
I just wanted to make sure I understood the time frame.
Thank you very much. Anything else? Thank you. The chair recognizes Ann Rice, representing the Attorney General, appearing in opposition to the bill, asking for 3 minutes.
Thank you very much. Good afternoon, Madam Chair, members of the committee. I'm Deputy Attorney General Ann Rice. I appear on behalf of the Attorney General in opposition to this bill. I need to correct a statement. Jury nullification is not the law of the land. juries do have a prerogative of jury nullification. The fact is that if a jury decides they don't want to convict someone, then they vote not guilty, and that cannot be appealed. So there is, in fact, a power to nullify, but that is not the law of the land, and I think it needs to be very clear. The language that was read by Representative Saporetto was a description of the concept of jury nullification. It was not the judge saying that this was an instruction that should be given. It was simply a discussion about what the concept of jury nullification is. And in fact, the court went on to say that it was not error for the trial court to refuse to give a jury nullification instruction. Jury nullification bills have been heard by, I believe, this committee at least 10 times in the last 18 years. I have been before this committee, I think, on every single one of those times. And every time the committee rejected the idea of requiring the issuance of a jury nullification instruction. Instead, in 2012, after a full biennium of votes, re-referral to the committee, non-concurrence, committee of conference, the legislature enacted Chapter Law 243, which has been referenced here. And that was after a good deal of debate about what should be done in New Hampshire on this issue of jury nullification. What's now being proposed is to disregard all of the work that this committee did in those 2 years and to start the debate all over again. And I would urge you to vote this ITL for the same reasons that you've heard for the years, at least for the last 18 years, which I think I've been talking to you about it. Its impact would be devastating to the criminal justice system. The bill would undermine a fundamental premise of our form of government, which is that we are a society of laws. We live by laws. House Bill 1452 completely contravenes that premise because basically what it's saying is if you don't have to follow the law if you don't like it. If you think that the law is unjust, you don't have to apply it. And that's directly contrary to what the juror's oath is, that they will render a verdict in accordance with the law. So when the juries start deliberating, they are under an oath to render a verdict in accordance with the law. We don't want the judges to turn around and say, well, by the way, you don't have to do that. You don't have to follow the law. Basically, what this bill would do is be encouraging jurors to sit in judgment of the laws that have been enacted after a lengthy process of public hearing and debate, laws that have been adopted in accordance with our democratic system. And one juror could negate that entire process by just deciding he didn't like the law. Fundamentally, it would change a criminal trial. A prosecutor would not only have to prove the elements of a crime beyond a reasonable doubt, but would also have to prove the reasonableness of the law to the jury. And it may require subpoenaing legislatures to testify about why the legislators established or enacted the laws that they had. Now, as you know, rarely, if ever, does a law get passed unanimously. But if this bill were passed, it would effectively require a prosecutor to prove to all jurors in a jury that the law under which the defendant was charged was a reasonable one. And if one juror disagreed with that, it would result in a hung juror. Jurors are told now, if you find that the state has proven beyond a reasonable doubt that the defendant committed all of the elements of the crime, then you should find the defendant guilty. If you find that the state has not proven the elements beyond a reasonable doubt, you must find the defendant not guilty. That instruction, our Supreme Court has repeatedly said, is sufficient to alert the jury to its prerogative of jury nullification. My question is, why would we want to do this and why just jurors? The message that you're sending, if you were to pass this law, is that laws really don't mean that much. Despite all the process that we go through in trying to determine what laws are good for our state, jurors, you can ignore them. And do we want to pass that message on to jurors? Do we want to pass that message on to other people in this state? How does this impact police officers and prosecutors? I have an obligation to charge people as a prosecutor, to charge people who violated the law. But I can't imagine that you would want me to make those decisions and say, well, I think this law is stupid. We're just not going to charge these things. I think this sends a very poor message to our communities, and I think that it changes fundamentally the way criminal trials will progress. So I would urge you to vote this once again ITL, and I'm happy to take any questions.
Thank you. Are there any questions for General Rice? Yes.
Thank you, Madam Chair. Attorney Rice, do you have written testimony? You have very good points of things you pointed out. Do you have that written testimony?
I have my outline. I'm happy to provide my outline.
That'd be good.
Thank you very much. We appreciate that. Representative Sylvie.
Thank you, Madam Chair. And thank you, Attorney General Rice. Once upon a time, it was illegal for slaves to run away from their owners. Many people sheltered those slaves, contrary to the law. Jury nullification was effective in protecting those people who aided slaves in their escape. Is there a problem with that?
I think that there is a recognition that there are times where a jury may decide that they think that the law is unfair. And that's how the whole concept of jury nullification came to be. But there is a difference between behind closed doors, a jury deliberating and saying, we just can't condone this, versus specifically telling jurors, you can ignore the law and you can do whatever you think is right, and regardless of the law. We recognize that there are times when a jury exercises its prerogative of nullification, and there's nothing that can be done about that. But it doesn't mean that we should condone people not following the law.
Representative Waters.
Thank you, and thank you for taking my question. I have to admit, jury nullification has always seemed like a gray area. It seems to be, what I hear you saying is, juries can have a right to nullify a verdict, but not the right to be informed by a judge that they have this power.
The jury, because of the nature of our jury system, they have the power to do it. Because behind closed doors, jurors can do and will do whatever they want. But that's different than saying to someone, you have the right to question the validity of this law. If the jury finds, and this comes from history where it was laws that were imposed by the king. It was not a democratic process, where laws were being imposed by a king and people disagreed, and it was their only way of civil disobedience and to show their dislike of the laws. We don't have that kind of a system anymore. We have a system where there's full public debate about the enactment of laws. So we don't need that kind of a system with the civil, when juries disagree with the laws by their verdict. We don't have a power to do anything about it. But we don't want to encourage people to ignore the law. And I know that it's sort of a difficult distinction between power and right, but jurors do not have the right to disregard the law. In fact, they take an oath that they will not disregard it.
Follow-up?
Yes, thank you. So, do you believe that the majority of jurors understand that they have the power of jury nullification?
I think that jurors routinely will vote what they believe is just in their hearts or based on the evidence. but I don't think that jurors are instructed, other than what we call the Wentworth instruction, which says, if you think the state has proven its case beyond a reasonable doubt, then you should, not must, you should find the defendant guilty, which is what the court has said is sufficient.
Representative Harden, do you have a question?
Yes, even without this instruction, aren't there a couple of safeguards? Well, first of all, the legislature can change the law if it's unjust. I'm not sure. But also, can't a person either be given a lesser sentence or even pardoned by the governor and council if the circumstances of conviction were manifestly unjust?
Sure, there are all of those. Yes, yeah. People can be involved in the legislative process. There's an annulment process. There's a pardon process.
Probably speaking out of turn, but of course we have incarcerated in this state countless number of people for acts which many rational individuals would not consider worthy of incarceration, but where there is mandatory sentencing. And among other things, that does show you the problem about mandatory sentencing. I'm just speaking myself, but there certainly are situations where that flexibility that we would all want to see in a democratic society isn't necessarily there. Now that I spoke out of turn, and shouldn't have said that, I recognize Representative Hopper, who's clearly free to do the same thing.
Thank you, Madam Chair. I'm paraphrasing, but you said that the jury is instructed to decide based on the law, so therefore jury nullification kind of contradicts that. But if jury nullification is the law, there is no contradiction.
Jury nullification is not the law.
Right, I'm saying if this is in the law, then there is no contradiction, correct?
Oh, well, yes, I mean, the law would be inconsistent because on the one hand, jurors have to take an oath that says you will render a verdict in accordance with the law, which is what they have to do. That's their obligation. And then on the other hand, in another law, you're saying jurors, you can disregard the law if you want to. That's inconsistent.
Representative Hackler.
Thank you, Madam Chairman. Thank you for taking my question. What changes were made in the last legislature?
The legislature adopted a new section of the law which says, in all criminal proceedings, the court shall permit the defense to inform the jury of its right to judge the facts and the application of the law in relation to the facts in controversy.
Thank you very much.
You have a follow-up, Representative Hackle?
No.
No, you're okay. Representative Birch.
Thank you, Madam Chair. We discussed earlier a little bit the Cody case, and the quote that's referenced in this bill appears to be from that case. Are you familiar with what came right after that quote? And I quote, "However, the fact that a jury does have this prerogative to disregard the instructions of a court, even as to matters of law, does not establish an imperative that the jury must be informed by the judge of that power. After all, jury nullification is neither a right of the defendant nor a defense recognized by law." Does that sound familiar?
I'm familiar with that, yes.
Thank you.
Are there any other questions? Thank you very much.
Thank you. Can I come forward just to give you my notes?
Absolutely, thank you. And meanwhile, the chair recognizes Chris Keating, representing the Judicial Council, who has observed us enough to be specific, and he has asked for 1 minute and 30 seconds to oppose the bill.
Thank you, Madam Chair.
Representative Hopper, will you please keep time?
Thank you, Madam Chair. Chris Keating on behalf of the New Hampshire Judicial Council. Speaking in opposition to the bill, I ran the Public Defender's Office for 12 years and supervised 120 attorneys at a time, and they were handling the majority of the criminal trials that were happening in the state of New Hampshire. And was responsible for training them, and am certain that every time they explained the Wentworth instruction to juries, they were allowed to do so by the judge. They were allowed to explain to the jury that the Wentworth instruction, which says that if the state proves each and every element beyond a reasonable doubt, that they should they should convict the defendant, but if the state fails to prove each and every element beyond a reasonable doubt, that they must acquit the defendant, was evidence of the existence of a prerogative in the jury to acquit the defendant, even though the state had proven each and every element of the offense beyond a reasonable doubt. So I thought it was important for you to know that in the public defender, where the majority of the criminal trials are defended in the state of New Hampshire, there's general recognition and acceptance of the fact that judges will permit you to make that argument to a jury. I also want to say, please beware of mandating instructions in every case. You can imagine that in a horrific child sexual assault case, if a judge were to give an instruction about the concept of jury nullification as it's described in this proposed statute, that could undermine, I think, in juries, respect for the court, a respect for the judiciary, a respect for the process, to think that in a crime such as that any intimation that the law that protects children from abuse is illogical or shouldn't be applied. I just think that's a very, very dangerous place for us to go. You don't want jury nullification in every case as a defense attorney. There are some cases where you say to yourself, you say to the jury, this was an ugly crime and it's terrible that it happened. It just wasn't my client who did it. So jury nullification as a concept is really just not applicable in all criminal cases as well.
Thank you, Representative Cobb.
Thank you, Madam Chair. I'm not positive what the law is now, but I know years ago, if a young man was, I think, 17 and the girl was 15, he could be convicted and actually put on the sexual predator list. Wouldn't that be, using your own example, under that circumstances, a perfect example of how jury nullification would be used, in that you don't want a 17-year-old kid being put on a list as a predator for the next 50 years because he fell in love with a girl who was, 2 grades below him?
Depending on the facts of individual cases, that situation similar to that could really be an appropriate instance for the argument being made to the jury. But I think as a society, there's a delicate balance that you want to strike between making sure that the jury is informed in appropriate cases of their prerogative while still instilling respect for the law and reminding jurors of their obligation to follow the law. I think the current circumstances in New Hampshire, I think they really do strike that correct balance right now.
Representative Burrow?
Yes, thank you. Attorney Keating, since we passed the law last year, since then, do you have any evidence, do you have any facts that a judge has declined to allow the criminal defense attorney to give this instructions to the jury?
No, sir.
Thank you.
Representative Hargan?
Yes, I guess I'd like to actually put your previous role as a defense attorney. Could this jury, first of all, they have this prescribed formula which the judges, we may or may not find the jurors understand it exactly the way it's written. Like, it certainly is one funny word in there, exigent circumstances, which I think even I would have to think several times before I would sort it out. So is there a danger or possibility that perhaps this might become the only instruction you can give in this topic and they wouldn't be able to restate it? Or because, like, in this, we got a document from the Assistant Attorney General yesterday where they're talking about how you have to they're saying the same thing that was in that 23A, and they restate it several times in different languages. Are you concerned that maybe this might prevent a judge from then also amplifying on it and restating it to make sure people understood it?
If I understand your question, Representative Horgan, I just think it's dangerous when you mandate a particular instruction for all criminal cases. Instructions need to be tailored for the facts and circumstances of specific cases.
Yes?
Could this also maybe prejudice cases you have a defendant who perhaps is, there's, the jurors are inclined to be prejudiced against? Let's say the jurors think because the defendant's a state rep that maybe he's prone to certain types of behavior according to other people, and
I'm sorry, that, you know.
But I mean is could it also prejudice a jury so they think like this person should be guilty of something, so even if they're not as certain as they should be that the particular charges apply, they might still convict them of something like happened. There was a British nanny who was convicted in Massachusetts around 1997 under circumstances like that.
Well, I think you make a good point in that we want jurors to follow the law. Even as a defense attorney, I want them to follow the admonition of the judge that prior bad acts of the defendant can't be used to prove that they committed the offense that the jury is dealing with. So we don't want to pick and choose which laws we think jurors should follow.
Thank you very much. I see, Representative Easton, you have your hand up?
Yes, thank you, Madam Chairman. I guess my question is, are you saying that right now a judge can tell the jury that they can ignore the law?
No.
Or not, depending on what the judge feels like that case is? I guess I'm kind of asking the same question that he asked.
Okay, but let me, I've done a terrible job explaining it, I'm sorry. Let me just be really clear. In every single criminal case, a Superior Court judge in a jury trial must explain to the jury the Wentworth instruction. And it's called the Wentworth instruction because it comes from a case called State versus Wentworth. And that Wentworth instruction, in that instruction to the jury, the judge says, if you find that the state has failed to prove each and every element of the offense beyond a reasonable doubt, then you must acquit the defendant. However, if you find that the state has proven each and every element beyond a reasonable doubt, then you should find the defendant guilty. And so that distinction between they must acquit versus they should convict allows defense attorneys to make the argument to the jury. And I've done this, and I've stood in front of a judge and I said, okay, so here's what that means. And if I'm saying anything that's not right, then the judge is going to stop me. And I look over at the judge, and she doesn't stop me, and so I keep going. And I say to them, that language, that distinction between must acquit and should convict means that you should convict. You are not obliged to convict the defendant. You should convict the defendant. And the fact that they say that you are not obliged to convict the defendant means that in appropriate cases you can use your own common sense to acquit the defendant. And I go on at some length, and the judge never stops me, because this concept of jury nullification is enshrined in that tiny little legal distinction in the definition of words between must acquit and should convict. And I think that strikes the right balance. I don't think we want to enshrine more than that in the law. You know, I'm supposed to explain things to people for a living as a lawyer, and I think I'm failing. So
It's just a very subtle.
Madam Chair, first of all, I'm going to apologize to you because I told you this morning I was just going to sit here and listen for a few sessions. But
And if you remember, I said to you...
I have a question. This law, as being proposed, is explaining to a jury their authority. Are you telling me that somebody else should make the decision whether or not the jury is informed that they even have that power?
As a defense attorney, I want that power. I want that. I want, in my independent judgment, I want the ability to make the argument to the jury when I think it's appropriate, when it fits with my theory of defense. I don't want a jury nullification explanation to the jury if that's not what my defense is. And the current state of the law, under the Wentworth instruction, jury nullification exists as a prerogative of the jury in every single case. As a defense attorney, I choose to explain that prerogative to the jury or not, based on what I think is in my client's best interest.
Paula? So you as a defense attorney want to have the ability to sway the outcome of the case by not informing the jury of the power that they have. I mean, that's what I'm reading, and I don't like it.
Well, respectfully, Representative, if your question is my job as a defense attorney to try to sway the jury on behalf of my client, it's yes. That's yes.
Getting back to shall and must, is that where we were?
Yeah.
Those are a couple of legal terms.
Sure.
And I wonder, even after explaining this to jurors, how many of them understand with good reason, with a good, fair comprehension, what those words mean?
Ideally, at least one of them. And in the, and in the context of a jury trial, whenever I appear in front of you all, I'm very conscious of how limited the time you have is, and so I kind of rush. And in the context of a jury trial, when my client's freedom is on the line, I take as long as I need to make sure, until I start getting nods from everybody. That's when I stop talking about jury nullification to a jury. And so it's my job to make sure they understand. I've failed if they don't. And so that's why we try to train the public defenders as best we can, so that they do a good job explaining this prerogative. Because it's a delicate little. You don't want to slay the goose that lays the golden eggs. I think jury nullification is that. I just don't think you want to hammer people over the head with it. It's like, if I could be permitted one little observation. The British were always like, why do you want to have a written constitution? The minute you write it down, you establish certain rights, but you exclude other rights that don't get included in the Constitution. We'd much rather have the gushiness of having it not written down. And I think I like the gushiness of being able to exercise jury nullification when it's appropriate.
Representative Rogers?
That raises the question, I've never been on a jury. Are juries given any written instructions?
Yes. The judge will give the judge's written instructions to the jury at the conclusion of the case and prior to deliberations in New Hampshire.
So that could be a place where, instead of relying on the judge to say something verbatim, there could be a paragraph about jury nullification in those written instructions?
Defense attorneys routinely, in appropriate cases, request a written instruction on jury nullification, and judges will occasionally grant it. Judge Perkins was no friend to the criminal defendant, and he gave a jury nullification instruction in a case in Coas County that I took over the representation of. A gentleman was harvesting marijuana to treat his severe physical ailments, and it was just sort of a grow your own operation, and the jury still convicted the defendant. But so my point is, judges can and sometimes do provide written nullification instructions when the judge considers it appropriate.
I just wonder why you have to pick that example. We're a little weird. If not seeing any other questions, thank you very much. And you did not do a poor job at all in explaining a very complicated issue. We're always very glad to see you. The chair recognizes Michael Brewster, who asks for 2 minutes in support of the bill.
Morning, Mike Brewster from Pittsfield. Now, where this law might have come in my case, again, I think you all know my case. 82, they took my child after getting an argument over my child's mother doing heroin, so the court removed me and only gave me an hour of visitation rights to visit my child every day and not to leave the town. Well, heroin and children don't mix, so I had my child quite often. And ex parte, they came and took my child too many times and brought it back to her mother. But it wasn't a very good living situation, living in crack houses. And then in '87, a guardian ad litem accused me of sexually assaulting my child. My child was in foster care. I had supervised visits twice a week, and then brought down to once a week, just an hour. And then when she got out of the foster care and placed with my mother, the child lived with me. I moved out, and the child lived with me. And after going to, Health and Human Services would stop over once a year. I'd scoop the kid over and make her look like she was living there. And then then she was back with me. After lying for a bunch of years in 90s, I told the court that I did have my child, that everybody was lying here. And he called me a liar. So pretty soon I'm dropping my kid off at school. I got arrested for interfering with child custody and thrown in jail. That would be just the same as that Rockefeller fellow that was living in northern New Hampshire here. How many years did he put in jail? But the courts made me go to a shrink. Shrink said I was incompetent to stand trial. But so I didn't have to go to court. They just dropped the case. But that's when Health and Human Services came in, boom, and started charging me with child support. Starting right that day, I got picked up for interfering with child custody. For if I did go to court, yes, I was breaking the law. I broke the law every day. I had my kid up to Canada. I had her in Florida. I had her all over. We were traveling. She was my child. I treated her as such, but I always had to look over my back. Never getting any paperwork explaining all this because the court withheld most of my paperwork, not giving me anything and not having any attorney. But if I did go to court, I could have been looking at 3 years. And maybe jury nullification would have lightened that up for me for if I did go to a jury trial. But the whole thing is nonsense. It still don't make sense to me, and it's child trafficking if you ask me. But that's all I have to say. It might have helped me. Thank you.
Thank you very much, Mr. Brewster, again, for sharing that with us. The chair recognizes Howard Zibble. You want to just give it to...
Do it on both sides. And there should be plenty for the clerk
we're
to
counting on that, Mr. Zibble.
take one for the record.
Why don't you start?
Thank you, Madam Chair. Howard Zibble, General Counsel to the Supreme Court and Judicial Branch. I think I've been here for most of the jury nullification bills that Deputy Attorney General Rice talked about. She's been doing this work a little longer than I have, but I've been here for the last dozen years on these bills. And I've tried to explain to the committee what is a very delicate balance. And I think Deputy Attorney General Ian Rice did a very good job today in explaining that delicate balance. Jurors take an oath to follow the law. As an institution, this legislature would want the citizens to follow the laws that are passed. Now, individually, you may not like some law that you voted against, but once it's passed, you can't pick and attention to that word should. Any judge will allow that argument to be made. We've struck that balance by the Wentworth instruction and leaving for
appropriate cases in the sound discretion of the judge to give what's referred to here as an enhanced jury nullification instruction. I think the Judicial Branch believes that balance has been struck in law well over the last many years and would urge this committee to ITL this bill.
Thank you very much. Representative Brooks.
Yes, thank you, Madam Chair. Good afternoon, Attorney Zibble.
Good afternoon.
If, after we passed the law last year, the judge refuses to allow defense counsel to discuss jury nullification to the jury, isn't that either or a appealable issue or an issue to take before you, the JCC?
It would definitely be an appealable issue. I don't know any cases, though I don't see all the cases that come in. So since that law took effect, I believe in January of 13, I don't know of any cases that have raised it. As I testified the other day, technically, you could have a potential judicial conduct issue if the judge blatantly refused to, knowingly refused to follow a law.
Thank you.
Thank you.
Thank you, Madam Chair. Is it possible for us to get a copy of what you read from, that you have highlighted in
I
yellow?
could provide that.
Thank you very much.
Would it be okay if I use the email? That'd be a way to distribute
Yes, that's
the
fine.
mail to all.
Thank you very much. I'm sorry, Representative Sylvia.
Thank you, Madam Chair. Thank you, Mr. Zibble. You spoke of Justice Nadu's stating that nullification is not the right of the defendant. Is that the quote?
The quote is, "It is well established that jury nullification is neither a right of the defendant nor a defense recognized by law."
Thank you. So that's not the right of the defendant, but is it a right of the juror? A lot of times we get into legalese, we speak to one thing and skip over possibly some other pertinent issue. I guess what I'm asking, I'll ask you more directly, pardon my ramble. Jury nullification, would that be part of our Constitution, Part 1st, Article 4, right of conscience?
I don't know if the right of conscience particularly subsumes jury nullification, but it may. I don't know if there's any case law that reaches that. But jury nullification, I think Deputy Attorney General Rice put it well, it's a prerogative of the jury. It has deep roots in our history. I do this high school program on the Constitution and Bill of Rights, which we just did in these rooms last Friday. And in the materials, the book that the students read, there's a description of the Zenger case in the 1730s or 1740s, where Mr. Zenger was charged with sedition. He had some ink in a printing press, and the Crown charged him with sedition, and he did violate the law, but the jury refused to convict. That's jury nullification. Is it a right? I don't know if I call it a right, but it's definitely a prerogative of the jury. The jury is allowed to, deeply within our traditions, to disregard the law. And you had some very good examples in the slave issue. Juries have that right.
Thank you very much. Representative Marcus?
Thank you. Do New Hampshire juries all receive the same written instructions?
Well, the instructions are tailored to the case. So the instructions are case specific. But the Wentworth instruction is supposed to be in there. It's in the model jury instructions, and it is supposed to be in there in all criminal cases.
Is it written down, or is it spoken by the judge?
It is both. It is given orally, and then the jury will get a copy, as I understand it. I've not tried a criminal case.
Thank you, Madam Chair, and thank you, Mr. Zibble. What is the Wentworth instruction? Who dictated that the judge, A, should give it maybe verbally and a written instruction, where was the genesis of that?
State versus Wentworth, right in the books and the citation
Right,
is
but
on there.
who required that the judges give that instruction in New Hampshire courts?
The Supreme Court wrote the opinion and said this is the instruction that we think should ordinarily be given to the jury. It's become a fixture in the law in the last 35 years.
Thank you very much. The chair recognizes Tom.
Flo-
you have to help me.
Cloche, Madam Chairman.
Crochet. Okay.
Can I have something I've written?
Thank you very much. And Mr. Crochet is testifying in support of the bill. And for those who are waiting for our 1:30 bill, I do apologize. This is unusual for us, but obviously many people had pressing things to say.
Thank you, Madam Chairman, committee. Appreciate your time. Madam Chairman, members of the committee, thank you for hearing my testimony today. I'm Tom Cloche from Grafton, New Hampshire. I'm presently a retired analytical scientist with a degree in chemical engineering. My testimony is in support of 1452. I will reference the New Hampshire's Constitution and RSA, and I'm changing that. I will reference it after hearing some testimony today. My suggestions. I'm suggesting the word nullification, which is used 4 times, be replaced with the word instructions. This is not a nullification, it's instructing the jury. I'm sorry, I have to put that in. And that the section 1519:23B, that is for the judge, that's 1519 is for the court and the defense. That section, excuse me, I lost it. And the section 606:2A is the oath of the juror's oath. So there's 2 separate sections. I believe it should be in 606. I'll explain in a little while. These suggested changes would accomplish 3 things. 1, by changing the terminology to jury instructions, it eliminates the unintentional biasing of the jury in the decision, which is rightly a concern of the judiciary of possible swaying of jury decisions. 2, in section 1519, the legislature has no precedent of instructing the court's interaction with jury instructions in that section. Section 19 presently instructs the court how to interact with the defense and the facts in regards to the jury. Now, section 606:2 has a 23-year precedent of where the legislature has required both a quote, a precise quote, and its administration by the judiciary, which the judiciary has accepted the legislative precise instructions and words that are to be administered to every jury. This section still maintains the court's oversight and control administrating instructions to maintain an impartial jury. That's what we're all after today. I believe having an informed jury is vital to New Hampshire residents. And my third thing, because of testimony, we hear from the judiciary, but no one seems to read what the law and the statutes actually are. So before we get to that, this bill in paragraph 2, I would suggest on hearing testimony today, if it's all in front of us, a mistrial shall be declared in any case in which the court fails to give the jury instructions with the intent provided in paragraph 1. That doesn't mean a quote, it's the intent of the law, intent of this. That would eliminate the exact quotes and mistrials in my honest opinion. I do not see any rational reason why we would not want to instruct the jury of their constitutional rights for a better and more informed jury. I'm not into my conclusion because of testimony, excuse me. I'm going off on the cuff here. Once again, we hear about the oath of the juror following the law. There is no law in the oath. May I read it, Madam Chairman? Since I put in my instructions, I would not. RSA 606:2, oath of jurors. The following oath shall be administered to protect jurors in criminal cases. The quote is, "You solemnly swear to affirm that you will carefully consider," not follow, "you will carefully consider the evidence and the law presented to you in this case, and that you will deliver a fair and true verdict as to the charge or charges against the defendant, so help you God." There is a law, but it's consider, not follow. The word follow is not in there. And while I'm in my section with the New Hampshire Constitution Bill of Rights, Article 15, I apologize, I was not going to read it. This committee heard enough. But I'm going to skip down. I won't read the whole thing. You can check that out yourself. But in there, no subject shall be arrested, imprisoned, despoiled, or deprived of his property, immunities, or privileges, put out of the protection of the law, exiled or deprived of his liberty, life, or estate, but by the judgment of his peers or the law of the land. You don't have to follow the law. You have either one. It's in our Constitution. I will get back to my...
Could I just remind you that you specified how long?
Okay, I'm in conclusion now. I apologize.
Great. No need to apologize. I'm just reminding you.
Thank you. In conclusion, the bill is instructional with these changes of one word, places the instructions for the juror, explaining and complementing his existing oath equally in all courts, defining the rights of the juror without bias about the charge to nullify, acquit, or find guilty. And the instructions in 606:2, where I suggest, is consistent with present instructions and a precedent of judicial acceptance. And thank you.
Thank you very much for bringing that to us. Are there any questions? If not, I thank you again. Is there anyone here who has wanted to speak on House Bill 1452 and has not yet been heard? Representative Hopper?
Madam Chair, if it's okay, could I just ask you a quick question of Mr. Zibble?
Certainly.
Mr. Zibble, we're told that, I didn't think about this till today, but we're told that the defense attorney has a right to inform the jury of its right to nullify. So a defense attorney can currently do that.
At least call attention to the instruction that's going to be given that says should.
So this is started to concern me is it possible, because that's just the defense attorney making an argument, is it possible for the prosecuting attorney to turn around and start citing actually some of the things that you said and trying to argue against nullification, or argue against the jury's right to nullify, therefore confusing the jury whether or not it does or doesn't have that right?
What the prosecutor is doing is saying why they should convict. And the prosecutor would have every right to argue, and all the arguments that the prosecutor could muster as to why they should convict. And the defense attorney was given the arguments of why they should not. That's how our adversary system works.
Follow up? So in effect, by the time that the jury goes to sit down to deliberate, it would be perfectly, under that circumstance, understandable for a jury not to fully understand whether or not it even has a right to nullify, much less understand nullification itself.
I guess I probably have more confidence in jurors than you are expressing right now.
Okay, thank you.
Thank you very much. Not hearing and seeing anyone else, I close the hearing on House Bill 1452. I apologize for us running so late, but people have a right to be heard.